So, hello everybody. Are you out there? This is the Staff One presentation on background screening, and it's being hosted by Staff One and powered by Track One, as we talk extensively about the need and the key issues behind background screening. And today we have as our presenter Mrs. Nancy Lynn Roberts in hosting for Staff One. And we're waiting for a technical element for Donna Meeks to come on board with us. So Donna, I don't know if are you there yet, Donna? Can you hear us? Are you connecting in? We're just waiting a second here for Donna to come on board. But if you're here for the Staff One webinar on background screening, you've come to the right place. So just, if you'll bear with us for just a minute as we work to get Donna on board, we will get started momentarily. So Donna, can you hear us yet? Are you connected on? If you can click a link to participate to speak, we would love to have your involvement. I don't hear her yet. Do you, Nancy?
I do not.
So I'm wondering if we ought to go ahead and get started here.
Yep. And really, we can just say thank you to you, Donna, because you are responsible for bringing us on board and for getting us, making this available to all of your clients. And I know what a dedicated service provider you are to them. So thank you, Donna.
So presenting today, we have Mrs. Nancy Lynn Roberts, the Chief Operating Officer, and really a driving force here at Track One. And Nancy's been a long time history in background screening and brings a wealth of knowledge to the table on this topic. Today she'll be addressing I would call it the background screening 101 and kind of walk through the key components on why you need background screening in your company. So Nancy, let me turn it over to you and we'll go this route.
Sounds great. Thank you, Rick. And again, Donna, we just want to thank you for making this available to your clients. And we hope that everything we've delivered today will empower them and empower you to understand and know what the obligations of all of the Staff One clients are when it comes to background screening their staff and their volunteers and even their contract workers. So we look forward to being a resource to all of you. So with that, let me just say to you that I'm going to do it's a pretty full amount of content for a short amount of time. And I might go through a few of the slides fast, but I think Donna will be making we will be making a link to this presentation available to all of you so that you will have this material as a reference tool and even as a training tool for your own staff. And so some of the lengthier portions of the slides I might speed through for purposes of today, but you will have that information at your fingertips down the road. And we hope that that is one way that we can have a lasting impact as a resource for you and your organizations. So with that, let me get started with just a few of the basics, just to make sure we all are on the same level playing field in our understanding about background screening. So one of the things that we're often asked by our clients, like each of you, is why exactly do I want to do background screening besides the fact that I want to get some information and make good decisions? Well, it may surprise you to find out that there's a number of reasons, but obviously, we do want to get to know our people before we choose to bring them on board in our company. It's, the difference maker between one company and the next company often is the talent that they have on board. So looking at their background, understanding who they are, and making good choices is mission critical. And to that end, what you end up doing when you make those good choices is that you do in fact protect and preserve your people, including your culture, your assets, and even your profitability. And in an interesting study done by the Small Business Association, they found that for every $1 that a company spends on background screening, they will end up saving their organization on the bottom line $16. So the value proposition is proven, and you can even get that SBA study showing that information. Attracting and choosing quality talent to your organization is another impact of implementing a quality background screening program. Quite frankly, great talent wants to go to a company that is doing great things to make sure that they bring on the right people. So your background screening program being stringent, being high quality, and being run and processed right and well will result in quality people applying for your positions and being attracted to your company. Of course, you want to be reducing your claims, liability, and exposure as a result of your background screening program. And a part of today is to make sure that you are setting things up and you are aware of some of the high-risk areas for background screening programs right now. So hopefully this will help you continue to do that. And then, of course, at the end of the day, what you're really doing is you're establishing a great brand for your own business. And the higher the quality of brand that you establish, the higher the value for your business, and overall, the higher value for your organization. So we are believers in background screening. We of course are engaged in background screening, but the reason we got into background screening is because we actually were in the business of staffing, and we discovered that by implementing a background screening program for our 5,000 employees at our staffing company, we were able to greatly reduce our risks, greatly improve the quality of people that we delivered to our clients. And that's really how we became believers in background screening. So with that, I want to make sure we all get on the same page about what the Fair Credit Reporting Act, which is the key federal law, says about background screening. Most of you will probably have heard of this act, but if you haven't, it is the federal law that governs any information that is reported about a consumer by a consumer reporting agency. That language, consumer reports and consumers, really what we're talking about when we talk about a consumer report is we're talking about what you think of as a background check. So when you reach out to a company like Track One and you say, this person has applied with me, I'm going to give you their information, tell me everything you can about them, and Track One issues a report to you that tells you everything from their social, verifies their social security number, that it's valid, it gives you an address history and an employment history, looks up criminal records all across the country and in targeted locations for you, we might conduct a drug screening test for you. There's a number of things we can do, but ultimately what is delivered to you is a background check, and that check or that report is a consumer report under the Fair Credit Reporting Act. Now, this federal law certainly is the governing law that everybody needs to pay attention to. There are additional laws that we have to look at and we think about when we're thinking about compliance and establishing a background screening program. So everything from both federal and state screening requirements. So in particular industries, you might be obligated to conduct a certain type of background check on an employee that you're bringing on board. Being aware of the federal and state privacy laws, which may prohibit you reporting information about an individual. Federal and state equal employment laws, and we're going to talk at length today about the EEOC and how they have come to enter into some joint guidance with the Federal Enforcement Agency, the FTC, and the CFPB for the Fair Credit Reporting Act. That's an awful lot of acronyms, but we'll talk about those in a little bit. But additionally, there are state consumer reporting laws. So much like the Fair Credit Reporting Act, each state has the ability to implement their own state law. And while the Fair Credit Reporting Act certainly preempts those state laws for the most part, the states may implement something that is more stringent than the Fair Credit Reporting Act, and you would need to be aware of that in your state. It's also helpful to be aware of any state consumer protection laws in your state. So for example, some courts have decided, criminal courts have decided not to release things like date of birth or address with a criminal record. And so if you're aware that that is the case in your state, you might have to find some workarounds for making sure that you can find quality information about individuals in your location. So the overall goals of the Fair Credit Reporting Act is that it is at its heart and at its core a federal consumer protection statute. So really everything that we do when we interpret the Fair Credit Reporting Act needs to be looked at from that lens. The goal of the law is to protect consumers. So if that's the goal of the law, then how should we interpret this particular provision? Well, in addition to protecting the privacy and the rights of consumers as it relates to background screening or issuing consumer reports, it's also a law that's written to ensure that the companies like Track One, who are providing information about consumers, are providing information that is as accurate as reasonably possible. So there are some rules and obligations around consumer reporting agencies. Now, today's focus is not going to be on the rules for consumer reporting agencies, but really is going to be on the obligations of employers. And there are some key things that you need to understand about this law when it comes to thinking about the Fair Credit Reporting Act and background screening for employment purposes. The first thing is that there are expanded obligations on employers when it comes to the use of background checks. And that is simply because the government and Congress said, look, a person could lose their ability to get a job in this country if we don't put in place some mechanisms to ensure that their rights are protected. And that really is at the heart of the Fair Credit Reporting Act. So understanding that's important. And when we say that there's more burdens on employers, that would be relative to, for example, landlords. Employers have to provide both a pre and a post adverse action notice. Landlords only provide a post adverse action notice. So Congress felt like this area, employment screening in particular, required a higher level of burden when it came to protecting consumers. The other thing that's important to understand, and that is that as you're background checking and you're using these background checks, you must use them in a way that complies with the other employment-related laws. So, Title VII and non-discrimination, equal opportunity type laws, making sure you're not violating the ADA if you're getting drug screening information. So it's the Fair Credit Reporting Act is one of the federal laws that you would need to be considering. And then the third thing to be aware of is that really for the last 3 to 5 years, our federal enforcement agencies and the two key agencies that are enforcing laws related to the Fair Credit Reporting Act historically, those two key agencies are the Fair Trade Commission the Federal Trade Commission and the CFPB, which was more newly formed, the Consumer Finance Protection Bureau. Those two agencies are dually charged with enforcement around the Fair Credit Reporting Act. But interestingly, some other agencies have come to play recently, and all of those agencies have really been focused on compliance when it comes to the Fair Credit Reporting Act. So we've got a lot of information today that maybe five or 10 years ago we didn't even have. So to that end, I'll share that one of the key areas that the Fair Credit Reporting Act has gained some new interpretation, new guidance, relates to the use of background checks in the employment arena and how you do that in a way so as not to to disrupt or violate the United States equal employment opportunity laws. So the FTC and the EEOC came together and have issued a series of guidances on how to kind of how to manage your background screening practices in a way to make sure that you're not violating the EEOC laws. So as you can see, first the FTC issued guidance in early January of 2012, then the EEOC issued their first guidance in something like 20 years on April of 2012, and then jointly they issued more guidance in just this year, March 11th. So between those three documents, which are great documents for any organization to have at their fingertips as resources, those three documents really give the current perspective on how to conduct background screening in a way that is compliant with the EEOC. What I've tried to do for us here is just give you some key bullet points to take away from all three of those documents. I think together they're over 80 pages, so we can't cover all the details in this short webinar, but key things: you can conduct background checks, you can look at criminal records, credit records, medical records, social media. Despite what you might be hearing otherwise, nothing in that guidance says that those things are prohibited. In fact, they specifically say that they are appropriate forms of background screening. But what the guidance does say very clearly is that you must conduct an individual assessment of each particular person who's applying for each particular position. And you need to look at the individual who's applying and their criminal background check, their background, their records that are in question, and you need to compare that to the job or the position in question and the type of company that position is going to be involved with. And you need to establish that there's a job relatedness and business necessity for conducting the background check, for making the decision that you're making, and for determining in this way whether or not the person is in particular eligible for this position. So individual assessment. Additional takeaway: you must still be sure that you're not engaging in any form of discrimination, whether it be disparate impact. You must still continue to accommodate disabilities. You can use medical information, but only post-conditional offer. And rarely, from the perspective of the EEOC, should genetic information come into play. But when it does, it too should be post-conditional offer. And then where you're using a third-party company like Track One, we're considered to be a consumer reporting agency under the statute. In those cases, then you must comply with the Fair Credit Reporting Act. Now, I will add to that I hear so many companies say, well, we're just going to contact this guy down the street who used to be a sheriff. Well, that guy down the street is functioning as a consumer reporting agency, only he is probably not following all of the rules that the Fair Credit Reporting Act requires, which protect both him and you from lawsuits. So you really want to make sure that you are working with a CRA, a consumer reporting agency, that is adhering to the Fair Credit Reporting Act, is accredited, and is in compliance with all of the obligations. And then finally, the key takeaway is that the federal enforcement agencies are very focused on this area, and we'll talk about some of the ways in which they're really highlighting things. But today, I think one of the things I want to make sure we cover for you is just some of the types of background checks that you should be thinking about using in your organizations. Identity verification is one of the key things. Thinking about alias names, name variations, social security checks, looking at photo identification and comparing those to criminal record identification, using photos, fingerprints. All of those are forms of identity verification. Verifying that somebody's authorized to work, looking at a national criminal database and making sure you're getting verified reports rather than unverified reports. There's been a lot of litigation from organizations like Aspokio is one name that you might recognize. They are not operating in compliance with the Fair Credit Reporting Act, and that spells great exposure for their clients and others. Other types of background checks include state and county searches, whether they're targeted to known addresses or targeted to where somebody previously worked. Resume verifications, whether you're verifying employment, education, or credentials, and reference checks. And then, of course, post-conditional offer drug testing, post-conditional offer physical testing. All of those are examples of types of background checks that you should be thinking about using in your organization. So key obligations for every employer, the 4 areas that you should be really thinking about when it comes to looking at what you're doing, how you're doing it, and are you making informed, quality, lawful, and quick decisions. So first of all, you want to look at your application. We're going to talk about ban the box, your written disclosure, and your written authorization that you get from your applicants. You want to think about your timing for doing your checks, your background screening, pre or post interview, pre or post conditional offer. You want to think about your process. You want to have a written policy and procedure in place. You should have criteria for your decisions with the basis for why that's your criteria in place. We'll talk about that today. You want to make sure you're using individualized assessment as required by that EEOC and FTC joint guidance. And you want to make sure you're giving a meaningful opportunity to every applicant that applies with you to respond to any background check that you are looking at. So if you get information from a third party and you're going to be using that to make a decision and it looks like there's adverse information on there, you would turn that over to the consumer and give them a meaningful opportunity to tell you what happened, what the situation was, what caused that, and what they've changed in their life since then. And then finally, your notice obligations. So pre and post adverse action notices, we're going to talk about today. The federal and state summary of rights, we will talk briefly about that today, which would be those rights would be attached to the adverse action document. Your third-party contact information, that means if you're using a background screening company like Track One, making sure you have their contact information in those notices. And then it's important for you to understand that every employer's obligation is to own the decision that they're making of whether or not to hire someone. But they don't have to own the information that they're relying on when they end up using a background screening company like Track One. That's Track One's to own. So really those notices end up clarifying for the consumer who's responsible for what. The employer's responsible for the hiring decision. The background screening company is responsible for the information that the company relied on in making the hiring decision. So the focus right now for employers that we're seeing, and what I want to really target you all in on, is some of the high-risk areas that we've seen creep up over the past couple of years because of litigation. So the first area that we're hearing a lot about, obviously, is whether you should include or ban the checkbox on your application, and we'll talk about that today. The second area I've already mentioned is this idea of that the EEOC says you must conduct an individualized assessment and do it in a way that does not result in disparate impact when you're looking at criminal records. 3 is you want to make sure that you are using the proper disclosure and authorization forms. There's been a lot of litigation in this area, and I think there's also some confusion in the courts in this area right now. And then the fourth big high-risk area that we're seeing is really just in the adverse action notices and the process that employers are following, the forms that they're using. There are a lot of technical violations that courts and plaintiffs alike are suing about, and awards are being won, settlements are being made. So those 4 areas are the high-risk areas we're going to talk about today. I will just casually mention that one of the areas we are watching is what is going on with staffing firms and clients when it comes to background screening. The FTC has been really targeted on that area. They're looking at, they've actually inquired of a number of experts and staffing firms in the area over the past year. How do you operate? How do you conduct your checks? How does that relate to what your client does? Do you provide them a copy of the check? When are notices sent out? They are exploring that process. And whenever the FTC and CFPB are exploring one aspect of the background screening process, that means they're either going to be issuing guidance or they're going to be taking some enforcement action. There has been some hot litigation in this area as well over on the East Coast. I had hoped that we'd have some decisions in that area for today, but those decisions aren't out there yet. So just know that that is an area that is a hot topic right now that we'll be probably talking about the next time we offer a webinar for the Staff One clients. So high risk area number 1, ban the box and fair chance legislation. So what exactly is ban the box? Well, many of you have on your applications in one form or another something that asks this question of, have you ever been convicted of a crime? Maybe it says, have you ever been convicted of a felony? But some form of question like that. And then the applicant is asked to check a box. So when you hear about ban the box legislation, that legislation purports to get rid of that box, get rid of that question on the application. And much of that legislation is referred to as fair chance legislation. And it's called that because the proponents of that legislation really view that box or that check box on an application as being a barrier to anyone who has a prior conviction to being able to get meaningful employment. So this legislative movement is trying to get rid of the box on your applications. And in fact, there have been a number of states and local communities, cities, for example, and counties that have implemented either ban the box or fair chance legislation of some sort. So I wanted to provide to you all an easy place for you to go to get the most current guide that is available online and for free. If you go into your Google bar, you can type in NELP, which is the National Employment Law oh my goodness, I just went blank on the P, but NELP is the organization that really represents employees, and they are advocates for ban the box legislation. They have provided publicly a great guide for where we are on ban the box legislation. And in short, as of about 9/25/15, so just about a month ago, we had 19 states that had enacted ban the box for government agencies in their state. And usually that's also for government contractors in those states. Now, 7 of those 19 states have further expanded that legislation to also include private employers. And then there are 100 cities and counties that have enacted some form of ban the box or fair chance legislation. And I have added for you that as of literally 2 days ago, New York City announced that they have enacted ban the box legislation as well. So it is reportedly a growing movement, although I think that many people are under the impression that, all 40 states or 50 states have enacted ban the box legislation. We are not there yet. We are still at 19 states. So it's not a majority of the states. So being aware of whether you are in an area where ban the box exists is important, and monitoring that is important. I will also tell you that on the opposite side of the legislative playing field is NFIB. They are opposed to ban the box legislation, so you can look to them for guidance on this legislation as well. Typically what this legislation does is not prohibit background checks altogether. That is not the idea. It also does not prohibit criminal background checks. A lot of people are confused about what this legislation does. What it does do is change the timing of when you do your check. So instead of putting that checkbox on the application, you would not be able to ask the question of whether you've been convicted previously until post-initial interview or post-conditional job offer, depending on what type of legislation has been enacted. So the second high risk area that we want to alert you all to is this idea of individualized assessment that the EEOC and the FTC have come out with. In short, what employers have done in the past is we've all had some form of bright line rule written into our policies and procedures. So for example, many companies will have a policy that says we do not hire felons, or if you apply here, these are the things that will render you ineligible for employment: any felony in the last X period of time, or any crime in the last period of time, or last X number of years. So those bright line rules are something that have been in place for a long time. And why we like them as employers is that there's no judgment calls. And for a long time, we believed that if we're making any sort of a judgment call, then we run the risk of being discriminatory. So if we have a bright line rule, then it's very black and white. We know the answer is yes or no to whether we're going to hire someone, and it's an automated decision. There's no risk of discriminating, right? It all made sense to us as employers. And we would automatically reject applicants. Sometimes it would happen so automatically that no human eye ever really looked at the situation for the applicant, and the applicant had no chance or consideration given, and really no opportunity to explain their past. So what the EEOC guidance that came out in 2012 said is, we don't like those bright line rules. So that auto rejection activity that you employers are engaging in is now prohibited. And in fact, saying you can't work here if you've been convicted of a crime or a felony won't work anymore. And instead, what the EEOC guidance said is you should be using individualized assessment. Now, I will say that the EEOC takes the perspective that that's been the rule of law for a long time. And, we could debate that all day long, but in short, there is a definite shift for employers from bright line rules to individualized assessment. And in the individualized assessment, you must have a written policy or procedure that spells out what you're going to look at for when it comes to background screening, and how you're going to process your background checks. Additionally, the EEOC requires that every job description would have specified criteria for determining employment eligibility based on that particular job description. So for example, your CFO position, you may not allow any felony in the last 7 years. But for example, for an administrative assistant at your front desk, you having that broad of a prohibition would be too broad, because there's no basis for prohibiting somebody who had a DUI 5 years ago from working at your front desk. So the EEOC wants your job descriptions to be very specific about the background checks that you're going to do and what will render someone ineligible or eligible for that particular position. The EEOC also wants you to have some sort of proof of non-discrimination, and what they're really, it looks like something got cut off there, but in short, what they want to make sure of is that you are not applying those criteria in a way that is discriminatory. So you've got to be able to establish that. And then they want proof that you looked at each application. If there was a negative background check that came back, you looked at that background check and you evaluated that relative to the position in question. Now I'm looking at our time, and I'm going to start to push forward pretty quickly here. There's quite a bit of information that you'll see in here about individualized assessment. And in short, the EEOC has spelled out for employers what factors they need to be looking at when they're looking at criminal records. So it's important that you look at those factors and use those factors in your policies and procedures and in your practices. Also, the EEOC has spelled out in their guidance what they view to be best practices, a great place to look to for crafting your policies and procedures. So I really urge you to get that EEOC guidance that I provided some information about. It's available online. Just Google EEOC criminal record guidance. The high-risk area number 3, disclosure and authorization forms. And in short, what you really need to know in this area is that you as an employer are obligated to have both a disclosure form and an authorization form that is signed by the employee or the applicant before they come on board. And that disclosure will tell them in a clear and conspicuous manner that you are going to be conducting a background check, and it's going to tell them what types of background checks you will be conducting. And it is also going to spell out for them the name of the company that's going to be conducting those. Now, please note, if you are doing any sort of reference checks or interviews, which is very different from verifying employment, but reference checks or interviews, then you also need to have a separate form of disclosure. So you'll have a background screening, background check disclosure page, and a second page that talks about the reference checks and interview process that you will go through to evaluate the candidate. Very important, and we're seeing a lot of litigation in this area. Now, your disclosure, there is some really a high amount of litigation on the disclosure forms. A lot of employers have been trying to incorporate other things in their disclosure forms, including waivers of rights, administrative purposes only language, just all sorts of things. And in short, the courts have said that's not okay. Your disclosure form must consist solely of the disclosure about the background checks you're going to do. So be very clear about that. Now, in the authorization, that's the part where the employee signs or the applicant signs and says, yes, I authorize you to run these background checks on me for the purpose of this employment decision. You want to make sure that if you're getting electronic signatures, you're following the e-sign law. That's very important. And the other thing you want to really be aware of, high risk area that we're seeing right now, is that authorization should not include a waiver of any consumer rights, that you do need to have state law specific information on your authorization form. There are check the boxes to get a copy in each of those 3 states listed on the screen there. And then a technicality that's being fought in the courts right now, and my perspective on what the right answer is different from what's happening in the courts, but the courts are saying that the disclosure form should be on a separate page from the authorization form. Now, it is completely contradictory to some of the language in the statute, but there is a conflict in the statute. One part of the statute says they can be separate, another part says that they need to be that they can be combined. But what we're seeing is litigation. And in fact, back in 2014, Publix settled for a $6.8 million settlement with a huge class action over that very issue. You can Google that and look up that case. But remember, $1,000 per applicant over a 2-year period, that's the amount that Publix had to pay to settle that, just because they had a disclosure on the same page as the authorization. So you really want to be looking at that and evaluating or changing your practices in that area. High risk area number 4, your adverse action notices. There are 3 things that you should be doing. You must provide pre-adverse action notice to the individual. That is the notice that says, I've gotten this background check and something negative came back, and we're considering not hiring you as a result of it. Then you've got to give the consumer a meaningful opportunity to respond to that notice. The statutes and the cases, the FTC opinion letters all seem to say that 5 days is reasonable, as long as the employer actually then goes back, looks at what the consumer gives them in the way of information, and reevaluates their decision. If there's any automated process going on that prohibits or precludes the employer from doing that reevaluation, or if there's no evidence that reevaluation is being done, then you've failed on your obligation as an employer according to the courts. Then the third thing is, after you've made your decision, another notice goes to the consumer that consists of a copy of the background check, the summary of their rights, and some information about the company that provided you with the background check. So I've spelled out in this presentation the details about pre-adverse action and what the obligations are. The statute does spell it out pretty clearly. One thing to notice is that adverse action is defined as not just a decision not to hire, but really any negative consequence to an employee or an applicant. So it might be a decision not to promote or transfer, or not to add benefits, or not to increase compensation in some form. So any kind of decision that is viewed by the consumer as a negative one is going to be viewed as an adverse action. The other thing that's important to know for purposes of whether or not you are obligated to give these notices is that the statute says that if your decision not to hire or not to give additional compensation is based in whole or in part, and the way that the statute defines that and the cases thereafter is that if there is any negative information in the background check and that background check is in your file, then the courts will say you obviously based in whole or in part your decision on that negative information, regardless of what you say. It's not in your file, but the consumer calls the background screening company, requests a full file disclosure, discovers that you ran a check on them, sees the negative information in it. Well, right there, the court will assume that your decision was made based in whole or in part. So understand that just because you don't put it in your file doesn't mean that you didn't get the information, and that the consumer doesn't have a way to find out that you got that information. And then this is that whole staffing firm area that I referred to earlier, and we'll talk about that more in our next one. I think best practice in this area is really treat any negative information on a background check that you get, or jet background screening report, as an absolute trigger for you to need to send out adverse action notices. So we've spelled out for you what all needs to be included in your pre-adverse action notice. Basically, it's a complete copy of the report. There are mandatory notices that are provided by the federal government, and then some of the states actually have specific consumer notices. Track One sent out to all of their clients today, in fact, all of the state-specific consumer notices. There were updates to several of those. I think there are about 25 to 30 states now that have specific consumer notices that have to go out along with your federal summary of rights. So don't just send the federal one. And then you, of course, have to give that meaningful opportunity to explain, respond that we discussed. Then the other thing to be aware of when you're talking about the post-adverse action notice, it can be electronic. You need to remember to adhere to the eSign Act. And really, we view, while the statute allows for oral notice to be given post-adverse action, we view this the requirement of electronic or some sort of written documentation to provide proof that notice was given is really essential. That's a best practice recommendation that we make to our clients. The other aspect of post-adverse action is really what all is included in the content of the notice, everything from name, address, toll-free telephone number, an indication that the consumer reporting agency did not make the decision and cannot tell the employee why the decision was made, and then finally that the consumer has a right to a free copy of their report within 60 days. So when it comes to adverse action liability, every time a decision is made without following the proper process, you will expand the number of people who will sue you under the FCRA in a class action. And as you could see from the Publix and the other class actions, those add up when you're talking about anywhere from $100 to $1,000 per violation. So that's a summary of the 4 high-risk areas that we wanted to share with you today that you should be keeping an eye on. Again, you'll have a link to this presentation, so you'll be able to flip through and see these slides in a more slow way after this is over. Things for you to keep an eye on in background screening, things that are coming up according to Track 1. First of all, continue to watch the Ban the Box legislation. Continue to keep your ears open for large settlements, class actions relating to whether this disclosure form must be separate from the authorization form. We don't have a definitive case that really is at the Supreme Court level on that right now. We just have a lot of class action settlements because nobody wants to go to court on it with a class action in tow. So we'll be watching that issue over the next year. And then, as I said, staffing and client use of background checks and how those organizations work together is going to be more and more evaluated. We're going to see more cases coming out in that area, I believe, and even some guidance. And then new products that are coming out that are really helpful for companies like yours. One is we are seeing a real shift from I'm running a background check at the time I employ someone, and maybe if something happens as a risk during their employment, we've already seen a shift to annually rescreening everyone in your company. But now we're seeing a shift to continuous monitoring, which is very different from just rerunning your checks. Continuous monitoring is almost like a live feed. So if one of your employees over the weekend gets a DUI and then shows up Monday morning to drive for you, you would be alerted to the over the weekend DUI as soon as it becomes available in the public record. So continuous monitoring is something that we're seeing start to go live in the commercial sector. It's been out there for the government sector as a method of improving security, but keep an eye out for that. That's coming your way. And if you're not already doing annual screening, you should be. And you will be moving to continuous monitoring over the next few years, I'm confident. Then social media and privacy, that is a big area where more products and more offerings are becoming available. So keep an eye and ear out for that. And then mental health records. What the courts are going to do with the availability and accessibility of mental health records still remains to be seen. They are not widely available at all at this point for what many would say is good reason. But where that goes as we move forward is going to be, I think, played out in the courts and is going to become more and more of an issue. So keep an eye on that. So with that, do we have any questions, Rick? And I know I'm over my time.
Well, in light of the time, we will take questions. If people would be so kind to put their question in the chat feature, we will answer the questions, but we'll answer them offline. So questions are important. Please send them in to us. We'll address them and address them to you individually. And then, so I think at this point, we probably ought to wrap it up, Nancy, if you go to the last and closing slide.
Sure. Well, and I've got one question.
Go ahead.
That does Staff One already have this as a pre-configured service for a fee? So yes, Staff One has a program offering from Track One for all of their clients, and you know, Donna Meeks is definitely the person that if you are on the phone and want to find out more about the offering that Staff One has available, Donna Meeks is the person for you to talk to about that initially, and she will get you set up with Track One. And we will look forward to answering questions and being your service provider of choice. And we just thank Staff One for choosing us. Just to let you know, we are also the preferred screening provider to the National Federation of Independent Businesses. So we've been been endorsed and approved nationally. And we're thrilled to be able to be a national resource that is now being made available to Staff One's clients. And I think that's an indicator of the quality of service that Staff One is committed to delivering to their clients. So with that, I want to thank everyone for coming today. And Rick, I'll let you close us out.
Yeah, so again, thanks for joining us. And on behalf of Staff One and Track One, we just appreciate you being here with us. And the numbers are on the screen. You'll see an 800 number if you'd like to get a hold of Staff One and their email address, and also for Track One and our 800 number. But we'd love to work with you in any way possible. And thanks for joining us today. Have a great day, everybody. Bye-bye.